Could an occasional text to or about your ex make or break your custody case? Different text might make or break your custody case. And it's vital for you to know when to text and when not to text, or what to text and what not to text. Let's talk about it. I'm Jim Crayville, lead attorney at Crayville Family Law. Today we're going to delve into factor J of the best interest factors. When a Michigan court decides child custody, the judge has to evaluate multiple factors to determine what's truly in the best interest of the child. One of those factors is factor J. Factor J is particularly important because it assesses how well each parent supports and fosters the child's relationship with the other parent. Let's break down what the courts are really looking for, provide you some real-world examples, and discuss ways that you can position yourself favorably in a custody case. Factor J requires the court to review the willingness and ability of each of the parties to facilitate and encourage a close and continuing parent-child relationship between the child and the other parent, or the child and the parents. A court may not consider negatively for the purpose of this factor any reasonable action taken by a parent to protect a child or that parent from sexual assault or domestic violence by the child's other parent. Essentially, the court will examine whether each parent encourages a positive, ongoing relationship between the child and the other parent. Judges want to ensure that neither parent is attempting to alienate the child, interfere with parenting time, or make it difficult for either parent to stay up to date about the child's medical, educational progress, or well-being in any other regard. Let's start with a couple of positive examples. Suppose you and your co-parent have a bunch of disagreements. Everything seems difficult. There's conflict at every drop-off. But if you continue to send your co-parent updates from school about the doctor appointments or dentist appointments, when they are, or what happened at those appointments, the judge is going to look favorably on that factor. But let's consider a negative example. Your co-parent notifies you that they're stuck in traffic and they're going to be late for parenting time. This is the second time this year that's happened, and you're going to teach them a lesson to be on time. So, you leave with the children to go out for dinner, and you send your ex a text that says, "Sucks to be you. You were late. Kids and I are leaving. Bye." Your co-parent ends up messing out on parenting time because they were late for the transfer. Even if your court order has a provision that says that each parent needs to be on time, your decision to deny parenting time and then send a nastygram just because you had to spend some time waiting for them to show up is probably going to hurt you when the judge is reviewing factor J. Let's dive into some type of text that you can send or cannot. Any text with profanities or name calling are probably going to hurt you. Consider this. Your kid has a science fair at school. Your ex is out of town or couldn't be there. You could, A, encourage your child to call their mom or dad on the way back and tell them about their experience, their display, their prize, or whatever they won or whatever happened. Or you could send a text that says, "Hey, Susie, Sarah, attended the science fair at school this evening. I'm sure she'll tell you more about this weekend. I thought I'd let you know she won third prize." Or you text and say, "You know what? It looks like you ignored your kids again at the science fair. You failed to be there. I assume I don't have to explain that when you go negative, the judge isn't going to view that as positively as if you're cooperating." Now, there are relationships out there, I'm fully aware, that are highly, highly toxic. And if you're in one of those, you just have to avoid oral conversations. And you're stuck with texting. Because a text, you can slow down, write it, rewrite it. Think about what you're sending before you hit send. Because you got to stop and think. A judge is going to possibly read what I'm sending in a text. Because the other side's, of course, going to bring it to court. So, as you're probably all aware, some parents use a parenting app, a co-parenting app, like Our Family Wizard. And there are different options out there. And that app will then track what parents send in the way of emails, when they were read, what the responses are. And you can even have those shared where the attorneys can access it or investigators from like the front of the court can access it. And that will at least have people keep track of what's being said. So, what's a judge going to look at when reviewing Factor J? Are you bad-mouthing the other parent? If you're saying, your dad is always late for pickup, your mom's getting plenty of child support, she can pay for your sports equipment, or did your dad buy new furniture again? He must have plenty of money, even though he won't spend it on you. Even though the arguments might be true, you're hurting your child by stating them. So, number 2, I see this happen. People refuse to list the other parent on documentation, like school events or any kind of a sporting event when you're joining like a sports club. If at the beginning of the school year, you're going to fill out the paperwork and you have the option of listing the other parent as an emergency contact, do so. List them as an authorized pickup person, assuming that there isn't a prohibition on that. Medical records. You've got the option of listing the other parent on medical records. If you think they're going to abuse it, well, then go get a court order. Or go get your legal custody provision amended to give you sole legal custody. But unilaterally excluding them from school records, medical records, whatever the case may be, is going to hurt your position on Factor J. Thirdly, creating conflict during joint events. When both of you show up, for example, to soccer practice or at the school spring concert, there's no reason for you to be discussing problems between the two of you. Keep it civil. Stay away from each other. And at least when possible, show your child that you've got the ability to co-parent. Most parents have the ability to live in the same household for a period of time. You can survive a joint band concert. Let's talk about some positive behaviors. Notify the other parent of a scheduled doctor visit or dentist visit. If the other party chooses not to attend, well, send them a text about the doctor or dentist findings and recommendations. Another thing you can do is notify the other parent of school events. Even if they could sign up for themselves or read the school newsletter, telling them that there's going to be a concert or that the concert's been postponed or your child has a science project due is just good co-parenting. And it's going to bolster your Factor J best interest factor. Another thing you can do is encourage communication. Make sure that your child regularly communicates with the other parent, even during your parenting time. If they're young, facilitate a phone call or video chats. Again, you're fostering a relationship with the other parent. Follow court orders. Comply with parenting time agreements. Don't make unilateral decisions about the child's schedule. Don't disrupt the other parent's parenting time by scheduling things to take away their parenting time. You shouldn't have to say it, but support parenting time. If your child is going to resist visiting the other parent, gently encourage them. Judges expect parents to be actively promoting the relationship between the child and the other parent. Don't just passively allow it. Factor J is probably one of the most critical factors in Michigan child custody cases. Judges want to see that both parents are willing to set aside their differences and do what's best for their child. If you're involved in a custody case, demonstrating your cooperation, your communication, your commitment to fostering a strong parent-child relationship with the other parent can make a significant difference in the court's decision. When parents spread toxicity and a lack of cooperation, your child's going to be noticing it, and it's going to hurt their emotional well-being. Think about it. 1/2 of your child's DNA is from the other parent. So when you badmouth them, cut them out of the equation, speak ill of them, send a bad text to them, and your kid is aware of it, you're harming your kid because they're half of that parent. If you've got questions about your case, or you need legal assistance, or you need to change the way you've been doing things, or if you've been doing things well, anytime you're wondering about Factor J, feel free to reach out to our team of attorneys who all specialize in family law. We're here to help you navigate this process and protect your parental rights. Thank you for watching. If you found this information helpful, be sure to like and subscribe for more legal insights on family law and regarding child custody. Until next time.